but it's 12 installments. What happens is then the documents read that if a person misses a payment, then the rest of those assessments for that calendar fiscal year become immediately due. So let's say the person's missed 2 months, they now owe not only January, February, they owe all of the assessments through December. And then special assessments that are extended. So you specially assess, but it's not one payment that's due at one date. It's installment payments that go on for an extended amount of time, you know, a year or a 2-year special assessment. So just rhetorical questions. How many of you have this and how many of you think it's a good idea? So I'm going to touch on some of the reasons why we it's not a good idea. Basically, it makes it harder to collect your money. So back to the example, your assessments are $1,000 for the year. The person misses 2 months, but now your assessments are accelerated and they owe the whole year. So instead of owing $400, they owe $1,000+. It's harder to collect $1,000 than it is $400. Someone is much more easily able to pay $400 than they are to pay $1,000. But the even bigger issue is if this person files bankruptcy, that basically freezes, it creates a line in the sand. Everything that was owed up until they filed bankruptcy is now going to be taken care of in the bankruptcy. Ideally, we'd file a claim for that amount. So that, and a Chapter 13 can take up to 5 years to complete. So now that year of dues are basically stuck in the bankruptcy. They can get paid out through the bankruptcy, but it can take up to 5 years for you to get that money back out of the bankruptcy plan. So in the interim, the person doesn't have to pay their assessments to you for the remainder of, because that money is now being handled in the bankruptcy. So it creates some collection issues, especially if they go into bankruptcy, and makes it harder to collect. So we do recommend that associations consider having their documents redone if you have accelerated assessments in your documents, because it will make collection issues much easier to handle going forward. Next slide. One of the other big things we wanted to touch on was HOA collections. For those of you that are in an HOA, our firm offers kind of a contingent fee program. If you agree to adopt our collection policy, which includes adopting late fee policies, fees for when it gets transferred to attorneys, basically things that give us more teeth when we go to try to collect for HOAs. If you adopt, can we go back? Yep, right there. If you adopt our collection policy, what we do is we take your collections on a contingent basis. Once a year, once those assess all of your accounts are 60 days past due, every owner that's 60 days past due gets sent to us for collection at one time. We then will handle those collections and you won't get charged until we collect. The reason we don't offer this for condos is that HOAs typically have one assessment each year. So it's easy to get all the accounts in at one time each year and would do those in bulk. So it keeps the cost down. It's easier to handle. And HOAs are a little different than condos in that there is no HOA statutes right now. So we file what's called a maintenance lien, and we can only do that once a year. And it has to be within a very limited window when the HOA assessment is at least 60 days past due, but not more than 6 months past due. So it's very important that we get those accounts on a timely basis, and then we can do them all at once, and it's more cost effective for the associations. So any HOAs that are interested in that program, please shoot me an email and we can get started on that. I'm now going to hand it over to Liz. Next slide.
Hi, everybody. So I'm going to talk about the collection policy. It's important to have a collection policy because that'll outline the procedures for payments, late fees, interest, fines. It'll also set out the procedure that the association would need to follow. So that way the fines the collection is done in the same procedure, and it's easy to follow and just consistent from one unit owner to the next one. We'll go more into detail about the fines later in Dan's presentation. Also, there's an importance for the timeline to send these collections to us. Condos typically 60, 90 days past due. We need to get the collection started before the debt gets too large and it's harder for people to pay back. HOAs, like Billy was saying, 60 days past due, not more than 6 months past due. We cannot file the lien once the debt is more than 6 months old, and the HOA can lose out on money. And the same with the condo associations. You know, it's important to get these collections started so that way you can recover the money faster and less of a loss. Next slide, please. Okay. We specialize in condo and HOA law. We pursue all the remedies that are going to be allowed to you under your governing documents and the state law. We're going to try to get as much for the association as we possibly can. And then also helps to make sure that people don't fall behind on their assessments, again, to keep them current. Next slide, please. So we keep track of our collections, how much income is brought in for the associations, late fees, interest, any other monies that are kind of additional bonus monies for the association, and what is collected throughout the collection process. Since 2012, we've collected over 11.5 million net dollars for property for our associations. You know, it's important to keep all these going and accurate. Next slide, please. All right, when you have somebody in collections, it is so important to lock them out of their account. Having access to their account can cause confusion if they see two different balances, a balance from our office and a balance from yours. Yours most likely will not be the same as our balance because we're going to be including our attorney's fees, interest, late charges, anything allowed under the association documents. Also, if they're referred to collections, turn off ACH. That's going to give them the impression that they could be current, or they don't need to reach out to us to deal with the past due debt, which is still out there. You know, it doesn't give them as much motivation to even contact us to get this resolved. Then once we do have it in for collection, we're going to send out the FDCPA collection notice. This is also important since we do have to follow the FDCPA for when we're dealing with the owners. That's why also another reason where they should be coming to us for communication, should not be discussing the accounts with the unit owners. They really do need to come to us so that way everything is in compliance with the law. And that way there's no missed amounts due. Don't discuss the balance with them. You may provide them a payoff and it will not include legal fees or costs that we've already incurred throughout the process. And then if you give them that payoff and they pay that amount, that is a loss to the association because the full amount was not collected but it was provided as a payoff. So they were given the idea that that was the amount that they needed to pay. Next slide, please. This just reiterates the importance of this. Lock the unit owner out of their account once they come to collections. Turn off the ACH for automatic payments. Payments should come through our office so that way we can accurately record all the payments that are coming through and monitor the debt. No negotiating or talking about the balance. They need to come to us. If they have a sale for the property coming up and it's collections, then the real estate agent or the title company need to be referred to us to get the payoff, and we will calculate it out through the sale. Next slide, please. All right, I believe this will be on to Dan, actually. Oh, Dan, you're on mute.
Well, thank you. And nice job, Billy and Liz. And the reason we had Billy and Liz do the presentation is because they do the work. The truth is they know what's going on with all of your various collections, depending on which one of them is handling the particular one. And it makes it much easier for them. And a lot of times our property managers put names and faces together. So onward, rules being useful tools. And as it says, it typically can be created and amended by the board, no owner vote. I think everyone on this call likely knows that. I mean, there are rules that require owner votes because sometimes the documents require there to be a unit owner vote in order to amend the rules, but that is probably less than 2% of the various associations that we represent. The rules point, though, is that they can be easily changed doesn't mean that they should be frequently changed. So normally you should be able to figure out what your rules should be and enforce those rules. So next slide. We just said, but look out for the hammerback. And that's because regardless of what rules you have, and there's all sorts of language out there as to how you can say it, rules being found unenforceable by a court or rules being selectively enforced are two different things. But let's start with unenforceable. Courts find unreasonable rules unenforceable. Why? It makes perfect sense. If a rule is unreasonable in what it says or requires such that it's a cute way of writing around because I don't like Joe or Jan, I'm going to write a rule so Joe or Jan can't do whatever it is that Joe or Jan otherwise would have been able to do under the documents. Selectively enforced is even a larger problem. Everybody in the place happens to have, let's pick something that's frequent enough, a shed in the back or something like that. And you go, but you can't have a shed. Why? Well, your shed would be visible from the street, but almost every shed is visible from the street. And this can apply to sheds. This can apply to somebody looking for a hot tub. This can apply to all sorts of things. That's a court's going to say, wait, you've got 60 sheds in your 140 unit or condominium association or 140 lot HOA. I'm not going to tell one person they can't have a shed because you think you can see it from the road when, in all honesty, you can see almost every one of these sheds from the road. That's the type of thing I've seen it used with jacuzzis on top of patios. I've seen it not used though, because you should also understand what's not. People always want to increase the size of their patios. My patio is 8 by 10. It would really look better if it were 8 by 11. Yes, every patio might be better if it were 8 by 11. The problem is that 11, maybe not necessarily on homeowners association, but certainly on condo association, you're taking common element and turning it oftentimes into limited common element. You don't have the right to do that. So you can't necessarily okay making it bigger. Next. Next slide, please. Perfect. Makes rules that conflict. Oops, I forgot to turn my plan with the declaration or bylaws. Those are pretty simple. Those tend to be interest. Somebody else say, oh, our interest should be 18%, but when you read their declaration or bylaws, it says 12%, or it says 1% per month, or something like that. Or it says, for which we hate it, oh, it's at the Wall Street Journal prime rate. And therefore it changes every month or day, and you got to figure out what it is. Those are more of a pain to deal with than they are illegal. But the concept being you can't have rules or bylaws that disagree with the declaration, and you can't have rules that disagree with the bylaws. There's a certain hierarchy, and you know, as you look at this 703.30 sub 4, really what that section is saying is that the statutes control, followed by the declaration, honestly followed by your articles of incorporation, followed by your bylaws, followed by your rules. So if there's an inconsistency, the higher you are on that list, that's what's going to get followed. So writing stuff that's inconsistent creates problems. Next, please. Make rules and keep them a secret. It's not so much that people keep them a secret, it's that they'll have a board vote and change rules, and then not have something that sends it out to all the unit owners that goes, listen, we've amended the rules. Now they might send out the minutes and say, well, the minutes were sent out to everybody. Everybody should know. Yes, everyone should theoretically know. But if you really want people to know, write amended rules on your rules and then redline where you're making the amendment so everyone can easily see where the change was made. And then a month later, send out rules so that the red line simply included, or do it all at once, or however is easiest for you. But the concept remains the same, which is make it so that it's easy for everyone to follow your rules, which means also to have your rules as organized as possible. Next, please. make, don't make rules that violate the law. Kind of fulfilling problem. One of the things is it'll say, and these are some examples, but satellite dishes. Satellite dishes are covered by a federal law that's known as the OTARD rules, over the air reception devices. Those OTARD rules will apply and say essentially that satellite dishes can't be prohibited in some manners, and that can apply to lots of things. Satellite dishes, solar panels, there's some other laws that apply to that. Targeting children. People always say, we don't target children. Oh, but we prohibit children from swimming in the pool between 8 and 9, 9 and 10. I don't care what hours you pick. Why? Well, that's adult time. As soon as you say that's adult time, it means by definition, you're discriminating against children, which by also definition violates the HUD rules relating to housing. So you're just creating a problem for yourself. It says no emotional support and service animals. What if that said no tier 3 criminals? No tier 3 criminals who have to be registered on the sex offender registry. Does that seem like a reasonable rule for your association? It would seem like a reasonable rule off the top of my head. And for years, it was a reasonable rule that we would recommend. But in 2022, a case came down that sort of said, maybe not so reasonable. Why? Because who should decide where former convicts who are now released should be placed in society? And the answer is going to be, well, I'm not sure who should decide that. I really don't care where they're placed. We have a lot of kids within our community. I can tell you where they shouldn't be placed. They shouldn't be placed within our community if they're on the sex registration list. Sounds perfectly plausible until you start taking into account they can't be within a certain number of feet of schools, and every association would then pass that type of rule. So you know where all of the people who would be on the sex registry would be concentrated in those few areas that don't pass that kind of rule. So the court case effectively that came down said, that's nice. We understand your concern, but we think this is an area best left for the state to determine where a former convict who's likely out on parole is able to reside. Not for every association to decide, well, yes, you can live wherever you want, just not here. Those are some examples. Oh, we also use no emotional support and service animals. So let's at least talk about that one generically. Most documents that we end up rewriting talk about pets. HUD is really specific, and the Fair Housing Act is really specific that emotional support animals and service animals are not pets. Therefore, all your rules on pets do not apply to them. So if you're going to have rules that deal with animals, get rid of the word pets and make sure it talks about animals and the rules that are applicable to animals, because those same rules will be applicable to emotional support animals and service animals to the extent that they can otherwise still function as emotional support animals and service animals. So the owner still has to clean up after them. They still can be walked in a certain area, although otherwise they can use the property freely, relatively speaking. And I say it that way because no, you can't prohibit them from using the elevator. No, you can't prohibit them from using the hallway. Yes, you can prohibit them from going into the pool. Why? Because if they're allowed into the pool ends up being closed because the health inspector will close the pool. That doesn't benefit anyone. So that is a reasonable limitation. All right, next slide. Put rental caps in your rules. Don't put rental caps, we're essentially saying. It's a hard one to explain, but the short answer is this. The case law says you can't have it in your rules. Doesn't exactly say can't, but it certainly implies very strongly that rental caps, if you're going to have them, should be in your declaration or bylaw. Are rental caps appropriate for everybody? No. Why? Certain associations are designed to be rented. If you're in the Dells, if you're in Lake Geneva, if you're in Door County, your association may, and I stress may, be one that was designed to be rented. And that the concept is that they expect you to rent it. Or that you're in the rental pool and therefore absolutely you'll be rented as much as we can rent you. And that may be also true in Elkhart Lake, Wisconsin. It can be true in various locations throughout the state. So that gets back to the rental cap part of it. So then why does it have to be in the declaration or bylaws? Because one of the provisions of the statute says that use restrictions have to be in the declaration or bylaws, or at least that's the reading of a case called Apple Valley. In that case, the concept was, well, you can't prohibit me from renting because I'm allowed to rent, and the court ultimately said, and now I'm trying to remember if they said, yeah, you can rent or no, you can't rent, but either way, it was because of how it was worded within the documents. And the restriction could be in the bylaws, not just the declaration, which I think was the argument in that case. And therefore, the restriction was valid because it was upheld because it was in the bylaws and not in the rules, but it didn't have to be in the declaration. All right, onward. Next, perfect. Some positivity, here we go, some things you should do. All right, so if we can switch to the next slide. So I have seen rules that are 30 pages long. Figure out what rules you really need as a board. I cannot stress this enough, and go, listen, let's look at our rules. Have we ever enforced this rule, this rule, this rule, this rule, this rule? If you haven't enforced it, take it out of your rules. I mean, to have a rule just to have a rule doesn't make a lot of sense. So the concept is equally true that if you have a rule, enforce it. So if there's a rule that you have, the presumption is that you are going to be asked at times to enforce it. And it should not be hard for your board to go, yes, we're going to enforce that rule. Why? Because it's in our rules. So next slide, please. So there's a whole bunch nationally arguments of, should you have a fine structure? The answer is yes. And then how should it read? What should it read? How quickly should it come into play? And I think generically, everyone's position has sort of over the last decade become the same. People get one warning, one and only one warning. And then after that warning, they get fined under some sort of a progressive fine system. We'll cover that. But the best way to ensure that people consistently follow the rules, because I'm going to guess if you're on this call, you either live in or manage an association. And if you live in or manage an association, almost every association has those one or two people who are incapable, for whatever reason, of actually following the rules. The rules either don't apply to them or they view everything as an exception in their favor. And of course, they're also the same people who complain very quickly if somebody else somehow violates a rule and it affects them. That's why our advice is really simple. Enforce your rules equally, enforce them consistently, and then make sure you have a good enforcement policy. We'll get into that a little farther along here. And have a fine structure that's part of your enforcement policy that is progressive. All right, next slide, please. Fines and grievance policies. So progressive fines, we use this as an example, 50, 100, 200. I've seen 50, 100, 250. I've seen 100, 200, 500. The answer is, where is a court as to how much you can fine or how big or how little you should, the answer is really two-part. If you knew this answer, you'd never have to ask another question. What's the amount I have to find to change people's behavior? That's the amount it should be, but not so much that it's offensive. Because if a court would view it as unreasonable, it's not going to be enforced. And then the second part, which I view as probably just as important as how much are the fines or the warning, the initial warning, which is make sure who's ever complaining files a written complaint. And having, some complaint that's signed with the reference to the unit number, everybody's like, yeah, but I don't really want to get involved. I get you don't want to get involved. No one wants to get involved, but if everyone consistently does it and goes, no, I saw a violation, I provided the complaint. Our goal is not to make money by fining. Fines are a pain in the butt. Collecting fines are even a bigger pain in the butt. Enforcing fines that you've said you're going to go collect, that then someone's not going to pay, is even a bigger pain in the butt. But at the end of the day, it does encourage compliance with the rules, which is what you really do want. So now if you've got a signed complaint and you've got progressive fines and you're following your documents and you've got photos presumably taken by the person who signed the complaint to show, yeah, they were parking right in front of the fire hydrant. Click, here it is. Send the photo with the complaint, attach it to the complaint. I don't care. It makes it much easier for the board or property manager to go, yeah, that's their car. Yep, that photo accurately shows it. Yep, we're going to send them a warning letter or we're going to send them a fine. Onward. So this sort of goes back to what we just talked about. Do require complaining owners to provide and put in writing the photos, the video, whatever it is, and if possible. But the concept isn't so you can pound it over the other person's head. In fact, I'm aware of a case where someone created a big problem in an elevator and then denied it the next day. And the concept of the complaints is similar to this, in that they denied it the next day so strenuously that they believe they didn't do what we said they did in the elevator. Well, we had video. It's like, this is you in the elevator. And this is you doing what you said you didn't do. So we're going to solve that problem. And they go, oh, you're right. And then problem solved. The intent, ultimately you're going to share the complaint with the party who's accused of doing something. You're going to share the photos. You're going to share the video. You're going to explain. There better not be any retaliation, because that's not what we do here. That's not how we act here. We are an organization / association that wants to be run professionally. We want people to enjoy living here. We want it to be a place people talk about to go, that's where we want to live, not that's where we're stuck living because of X or Y or Z being the people you have to live with. That's the kind of message you want to be consistently passing on to all of the various unit owners. Next slide, please. So when the violating resident, first, but only once, that's just the warning. Make sure you give them that warning, then fine according to your enforcement policy, which we already talked about. Have time frames, which we didn't talk about. This is your warning letter. You have 3 days to correct the problem, 4 days to correct the problem. You pick whatever it is you can live with. But after that, they're fine. Day 5, they're fine. Why? Because if you consistently do what you say you're going to do and do it in a professional manner, people are going to respect that you're going to do what you say you're going to do. And if you follow through with it, they will start to figure out, because we've had this happen on many occasions with many of the people we collect from. Oh, I got that collection letter. Oh, I better pay it. And then they start paying more frequently because they don't even want to get the collection letter, because they understand the collection letter adds a whole bunch of costs to the amount that they owe. All right, next slide, please. So Fines and grievance policy. Boy, everybody might get done early today. Continued. So the grievance procedure, non-board member unit owners. Let me explain that so that it makes sense. A grievance policy that makes sense, or I'm sorry, an enforcement policy that makes sense is one that says, okay, the grievance decision is final. We don't want to go to court and fight about this. We don't want to arbitrate it. We want some neutral party to make a final decision. So let me tell you who can't be a neutral party. The board or property manager who instituted the fine in the first place or sent the warning letter and then instituted the fine on the second violation can't be a legitimate, true neutral party. You want non-board member, non-involved, non-conflict of interest unit owners to be on your grievance committee. How many times does the grievance committee meet? Very few. How do I know? Because I've been involved in about 3 of them, I think, over the course of 20 years, even though we've been recommending them. Now, do I know of more that have taken place? Yes. How many? Let's assume 20. 20 in 20 years out of 900 associations gives you a rough idea. Most people don't want to say, no, I want to have a hearing. I want to have it before the grievance committee. But let's assume someone does. The board can't go and pick a side. The board just is going to be there as a witness, just like anybody else, to testify in case they're asked questions. Well, how was this decided? Well, we had a board meeting. What did you talk about? The complaint. We looked at the complaint, the photos. They seemed reasonable. We sent a warning letter. Okay, then what happened? Well, then we got another complaint and we got more photos and we got, a picture and we saw, yeah, the car was parked in front of the fire hydrant to make this easy. Okay, and what'd you do? We issued a fine and we asked them to move their car. And of course, they were supposed to move their car within 24 hours so that we didn't have the fire department give us additional fines. Okay. So did they move the car within 24 hours? No, they didn't move the car within 24 hours. So we issued the second fine. And why is that? Because every day is a new fine when it's that type of a situation. It depends on how your documents read, but you can make them read that way and they should read that way. Every day is a new violation because they have the opportunity to cure it in the day that they had. So back to the grievance procedure itself. You're past all this fining at this point. Both what you would normally have is 3 unit owners sitting in the front at a table. And then 2 other tables, one being the complaining party and one being the alleged violator. And if any of them want to bring an attorney, bring an attorney. They don't really care. Followed by the complaining party tells you whatever it is they need to tell you. The violating party tells you whatever they want to tell you as more or less an opening statement. The complaining party can then call any witnesses the complaining party wants to call and ask them whatever questions they want to ask them. And if the committee wants to ask a question or 2, they can ask a question or 2. Then the complaining party gets opportunity, just like you would think, to cross-examine. This is just like giving them due process, an opportunity to be heard. They can cross-examine. When it's over, the complaining party gets to put on their witnesses. They get to ask them questions. Then the alleged violator gets put on witnesses. They get to ask them questions. Then the complaining party gets to cross-examine those people. And then when that's done, oftentimes the complaining party would have the opportunity, what's called to rebut whatever all these new people have now said. And we put on a very short rebuttal, but limited only to what those people have said. Then everybody gets kicked out of the room and the grievance committee makes the decision. And that's the whole point of the decision being final, is everyone's stuck with it. Generically, it seems as though most of the time they decide with the board, but I've seen frequently where they've not decided with the board or decided partially with the board. It's all okay. The concept is after this grievance hearing, you guys are all going to live still in the same association. You want to be able to get along with each other, even if personally you don't get along that well with someone. You don't want it to be a whole bunch of animosity. So generally I say, we're all going to treat this as though This is a judge making a decision. We're done. We're done after this, and we're all gonna live with whatever it is this person decides, or these three people decide. All right, and obviously they make a decision, and then that's it. So that's it, other than all of your questions. Where we at 12:37, so not terrible. I haven't looked at the questions. Has someone, or do you want me just to take a quick peek? Liz?
Yes, we've got a few. I just wanted to clarify, someone had a question on if condominiums and HOAs are different, and yes, they are. So in Wisconsin, condominiums are incorporated under Chapter 703. HOAs are typically planned communities or development subdivisions, those type of things that typically have standalone homes that aren't incorporated under Chapter 703. So condominiums, we're talking about only those organized under 703. Question, Dan, what about dog breed restrictions for insurance purposes? If a dog, and kind of is the dog, what if it is a service animal that is one of those restricted breeds?
From all the cases I've seen, as soon as you say it's a service animal, it's been trained. And I'm not aware of anything that lets you exclude that animal from your particular association, absent evidence that this particular animal has caused damage. I mean, I don't want to say it has to a bit, but there's some cases out there about aggressively attacking people or aggressively without biting. But generically, the association loses unless they can show that the dog/animal is violent or aggressive, such as to cause rational fear in other people. That's kind of what I've read, summarizing probably 15 cases on this. Okay, what else we got?
Next one, how do we handle satellite dishes when the roofing company states that putting satellite dishes back up after a new roof is put on voids the warranty?
Well, first off, they're putting satellite dishes then on probably common element. They're not entitled, I don't believe, to put satellite dishes on common element. I'm almost, I gotta tell you, I haven't had an OTARD question in probably 10 years. But having said that, I'm pretty confident you can't put a satellite, you don't have a right to put a satellite dish on a roof that's common element. And therefore, the problem sort of solves itself. If someone is allowed to place one on common element, then I would tell you have an agreement ahead of time saying you're not going to be allowed to place it on common element unless you agree that should we need to repair or replace the roof as a result of the satellite dish, that's going to be at your cost. And oh, by the way, if we have to replace the roof unrelated to the satellite dish, you're okay with the warranty being voided for the removal of the satellite dish and its reinstallation. I don't know what else you can do. The option is not let them put it on common element and tell them they got to put it on limited common element, which is normally their deck or patio. And then you work off of that because that's then their exclusive use area and it's their problem, not your problem. I hope that makes sense.
We redacted our complaint, so meaning the complaint from the person about another owner's behavior, to remove the informant's information. Is that okay? So when they send, I'm assuming when they send the notice out to the person who violated it, they're not giving the complainant's information. Is that okay?
At that point, sure. But if they're going to contest it in any fashion, then the complaining party's information has to be available. You can't cross-examine someone if you don't know who the someone's going to be until you're surprised when you walk into the hearing. Oh, that person. They have to have a fair opportunity.
What if the person who does not follow the rules is the board president?
Well, then the answer is really simple because If the board's still gonna find them, that's great. If the board's not going to find them, you've got two choices. One, file suit. I don't recommend that choice because you're gonna be jumping through a whole bunch of hoops and spending a whole bunch of money for no good reason. But two, go out and get enough proxies and kick the president out of there and find a different president. If you can't do either one of those, sell your unit and move. Because if the president doesn't follow the rules, you're gonna have more problems, not less problems.
What are your best practices for selecting non-board unit owners to hear the grievance? How many should there be?
I'm a big fan of 3, not more, not less. One's okay. I mean, as long as everybody agrees one's okay, I'm fine with 1. My experience tells me 3 is the best choice because you get alternative thoughts without so many people that it becomes a pain to do. That doesn't mean your grievance committee doesn't have 7 people on it, of which 3 serve for any particular grievance. But I would only have 3 people deciding a particular grievance. They
Okay.
cover them all? Oh,
Can we talk about interest charges and late fees for past due monthly assessments? I would say yes, we want those. Yes. We definitely recommend having collection policies that include late fees and interest. We want to collect everything for the association, but that is also our wiggle room in negotiating payments and payoffs with unit owners. So there are incentives to pay your dues on time, because if not, you're going to get penalized in the form of interest and late fees. And B, it makes collection a little easier because we have a little wiggle room, a little to play with, a little to incentivize people to get that debt paid off in one lump sum. So if you do not have those in your documents, we do recommend getting a collection to include late fees and interest.
yeah, and I'm a big fan of compound interest because, let's be honest, all of the Excel schedules naturally compound it. I don't think that's that big of a deal, but sooner or later, there'll be some judge who questions it and goes, it looks like you're compounding the interest. You're only entitled to simple interest. It's a complete pain to calculate. You just save yourself some headaches to have the right language.
We have restrictions on animals to say they cannot weigh over 20 pounds. Is this okay?
Not sure what a 20-pound dog can do or not do that a 30-pound dog can do or not do, but the basic answer is yes. The board can set any reasonable rule that it wants related to animals. I wouldn't. So I don't have a problem with it. You know you're going to get the 25-pound dog that, he just gained weight this month. And you're going to end up having those discussions. And how are you going to practically weigh the dogs? Because I can tell you right now, if somebody has the 40 or 30-pound dog, they're going to first tell you it only weighs 20. You're going to say, give me the last vet thing to show me what it weighed. You're going to say, oh, that was just that one exception. And then as soon as you get them trapped that it is, they're going to say, yeah, but there's 20 other dogs in this association that weigh more than 20 pounds. And then they're going to take some pictures of some dogs here and there, and you're not even going to know if those dogs live there. I can't tell you I'm a huge fan of it, but because it's hard to enforce. But if you're okay enforcing it, I'm okay with the rule.
All right. So adding an appeal process to the issue can be heard by the board of directors. In your opinion, does this strengthen the grievance process or weaken the process? Specifically regarding strength, weakness of the process as viewed through the lens of a court when determining reasonableness of an assessment.
We cross things there. So
Yeah.
the board does determine assessments. So the board has to determine assessments. So let's leave that aside for a second. Now we're talking about a grievance process where the board decides if there was a violation. The board probably initially, when they fined or sent the initial letter, determined there was a violation. So having the board involved in the grievance process to determine whether or not the fine in the first place or the warning letter was reasonable and rational doesn't, in my opinion, it weakens the process. It weakens the process because you don't really have an independent third party looking at it. You'd be so much better off with somebody else making that decision. Think of the grievance committee, if done right, as a third party arbitrator who's just deciding the case, but then you don't have to go to court.
All right. Next question. What about emotional support animals being an excluded breed? So is that going to fall in the same line as service animals, an emotional support one?
Yeah, I mean, the emotional support ones get pushed around so much because of, the law is constantly kind of developing on them. For a long time, you could get any animal to be your emotional support animal just by filling out some form on the internet, and having somebody from California who's allegedly a doctor send you a nice note saying how you need this emotional support animal because of your disability. And it just happened to magically perfectly track the statute. Having said all of that, my answer is, I think they're getting a little tougher. They know there's a whole bunch of violations out there, but I don't think you can restrict it based. I know you can't restrict it based on breed. Let's save time. You cannot restrict it based on breed. You can only restrict it based on what I talked about. The viciousness, attacks, that kind of thing.
All right. Where should fine schedules belong? Rules or bylaws? Do bylaws need to mention that there is a fine schedule? I mean,
Bylaws don't have to mention that there's a fine schedule. Bylaws just need to mention that the board has the authority to pass a rule. And ideally that the board has the authority to fine, issue late fees, all those other things that the board might otherwise want to do. You need to create an enacting system through which they can do it. So presumably that's going to exist within your bylaws. Having said that, your fine schedule, in my opinion, should be in your rules so you can change it, because in 10 years, you're going to change it. And it might be in 5 years, depending on how fast inflation affects whether or not a dollar amount's reasonable. We see ones still now and then, the initial fine will be $10 and people don't care. It's just not enough. So I would tell you to put it in, I would make sure it's progressive. I would make sure there's initially a warning, an amount, double the initial amount, and then maybe triple the initial amount. I mean, I would make sure there's a progressive fine schedule attached to it in the rules.
can the board sit on a grievance hearing?
Can they attend it?
Yes.
Yes. I mean, normally they're open to any of the, it's theoretically open to the public, I guess. It's not really. The board could, it's going to depend what your policy reads, but my basic answer would be I'd let any member come to the hearing portion of it. To the decision portion of it, no, they cannot attend, because that's the whole point of having 3 independent people make the decision.
When a owner dies and the unit is in probate, does that let the trustee not have to make monthly payments? If there is a personal rep or a special administrator appointed, payments should still be being made. And if they're not, it can come to collections. Especially if it's a personal representative, they step in as if they were the owner. Oh. Dan, you want to add on, or?
Nah.
All right.
I mean, we'll have, if there's no one appointed, we'd have, you got to get it to collection so that it's nothing else.
Yeah.
We're gonna have a special administrator appointed, but you two know more about that than I do. to be
Yeah,
honest
but
with you.
payments, even if they die, payments are still required. Yeah, we might have to appoint a special administrator to get it pushed through foreclosure. If there's probate, then we'd file a claim in the probate case and send it to the personal representative for payment. But yes, payments should still continue from somebody.
So dying doesn't get them off the hook, you're saying?
Right.
No,
No,
sure
treat
doesn't.
them the same. Treat them all the same. 60 to 90 days past due, we recommend they're in collections, dead or alive.
Okay, so this is regarding, so the next one, back to grievance. Selecting non-board grievance panels. Is there a best practice, as some might challenge how the panelists were selected?
Well, my answer would be this. Ideally, every year you would select them not relating to a particular grievance, but ahead of time, have 7 people on the list. Then if there's a problem that arises, say, listen, we've got a problem arising relating to unit 204, and here's the owner. Do any of you know them? Yes. Okay, you're off the group now. I mean, and I'm talking generically, know them better than just, yeah, I knew that person lived here. Assuming that doesn't happen, then you say, okay, well, I'm going to randomly draw the panel. Here's who I drew. Whoever it is, these are the 3 who are ideally the manager. In the ideal situation, the manager would do it. If there's not a manager, have a chairman of the grievance committee, have them draw it. Here's the 3 of us who were drawn. Can we make it? No. All right, well, 2 out of 3 can make it. All right, randomly draw one other one. I mean, that the concept is keep it out of the board's hands as much as possible.
Can the board impose penalties for late fees if they pay a late fee and or interest?
So let me break that one down, because
Yeah.
I think I can answer it, which is interest is a charge for not paying money on a timely basis. Fine. It's a monthly ongoing forever charge until the balance is paid in full. Leave that aside. That's one thing you can do. Second thing, as long as your documents authorize the board to be able to charge late fees, you can charge late fees. Late fees, in my opinion, by definition, is one late fee. Something's not paid on time, you charge a late fee. You don't get to keep charging a late fee for the same thing. So if somebody misses their dues in February, yes, you might charge them a $25 late fee and then interest going forward at whatever rate your interest rate is at. But in March, when they pay their March payment on time, you continue to charge them interest, but you don't get to say, oh, and your February payment's still late in March, therefore we're going to charge you another late payment. On the other hand, if they don't pay March gets a late payment and interest. So it works like that. One late payment per individual item that's not paid timely, and then interest.
Can the fine schedule be set up as a set of increasing percentages of monthly fees? So
Sure.
assuming the interest just keeps going up.
Well, yes, I have a feeling that way. The answer is that way you don't have to consistently worry about adjusting your fine schedule. So you're saying if somebody fails to pay, 5% of our monthly assessment is going to be the fine on the first violation. On the second violation, it's going to be 10%. On the third violation, it's going to be 20%. I'm fine with that. Or whatever. I'm randomly picking it because I'm not looking at numbers, but yeah.
How does the association respond to owners asking why specific owners have 2 dogs when one dog is a emotional support animal or service animal and have been approved with correct documentation by board? So the rules only allow for 1 dog, but yet they have 2 emotional support or service animal dogs.
Because they take the position that the other animal is an emotional support animal and therefore is not a dog or a cat under the definition. To me, it's crap. Just hear me out. It's crap, but it's not worth fighting. If you really want, you can just say you can have 1 animal. And then I can just tell you what's going to happen. That's going to be the same person says, I need 2 emotional support animals. Why? Because the first one gets exhausted from providing me with emotional support. So I need a second emotional support animal. That's what's been now. We've seen some of those cases around the country.
Are they allowed to tell the other owners that's why they get 2 dogs? That because they are a service animal or an emotional support animal?
No, because effectively by saying that, you're saying they have a disability, because without the disability, so you're disclosing some medical fact that you shouldn't disclose. You should simply say, we consistently enforce the documents as we are allowed to enforce the documents under the law.
Kind of just leave it general.
Yeah, leave it general, and that's as to everyone. If you have a complaint about someone, you can certainly tell us and, filling out the complaint. And then we can see where the process goes.
That's it for now.
Well, that's pretty good timing, 12:56.
See, somebody has a general question about a software system, which I'm sure some of the callers on here might be able to help with.
I'm really good at software. All right, I know nothing. Let's be honest. So I want to thank Elizabeth and Billy for participating in this. I want to thank everyone who attended for coming today. We really appreciate it. We hope you found it educational. We have another one coming up. I hate to say this, I'm not sure when, but we have it about 3 to 4 times a year. We will have another one coming up. We try to get out to you what the next one will be about, and we hope you enjoyed today's. Thank you so much for coming and have a great week. This is where we all leave. I'm hitting leave. Bye, everybody.